All right, Mr. Adams, who do you have with you this afternoon?
Your Honor, this is Juan Guzman Castaneda.
Okay, this is CR 21-120, State versus Juan Guzman Castaneda, and he is set for arraignment today. Have you had an opportunity to go over the indictment with him?
No, Your Honor, Mr. Guzman needs an interpreter. It has been a while since I've been appointed to represent him. He and I tried to visit once a few months ago, and it's should have been my responsibility to alert the court of the need for an interpreter, but I dropped the ball and I apologize for that. So we'd ask that today's arraignment hearing be reset so that we can have that accommodated for him.
Okay, let's do this. The court's going to set it for arraignment and pretrial, both on July 8th. And the court can reset the pretrial if there's an issue that prevents you from filing any pretrial motions that may need your discussion or counsel with him.
Yes, sir.
We'll go ahead and set it for both. That way, if you see any legal issues, you can go ahead and file those and we can get moving on it. So there's no unnecessary delay. And we'll request an interpreter for July 8th, and that'll be at 1:30.
Mr. Guzman, you don't understand anything I'm saying, do you? Okay. I need to come back over with an interpreter. Okay, so I'm going to make that arrangement, and we'll visit between now and July 8th. Okay. All right.
Mr. Adams, do you believe that he's understanding you, what you're telling him?
I'm sorry, Doug?
Do you believe that Mr. Castaneda is able to understand enough of what you're saying? If not, I can ask my court reporter to translate for purposes of letting him know that we're going to reset the case until July.
If she wouldn't mind, I'd feel better about things.
Okay, give me just 1 second here.
Yes, sir.
All right, back up. There we go. All right, go ahead. And this is going to be off the record, obviously, because Ms. Grisham can't do both, but she's just going to do this as a courtesy to the court. Go ahead, Ms. Grisham.
Oh, I appreciate it.
Vamos a volver el día 8 de julio. El día 8 de julio vamos a ver.
Okay.
Y el corte te va a tener un intérprete.
Gracias.
¿Está bien?
Sí.
Do you have any questions?
¿Tiene unas preguntas?
No. Okay.
Thank you, Ms. Grisham. Good afternoon, Mr. Gimbel.
Afternoon, Judge. We have Mr. Terry Elmore today, I think is set for a status hearing.
I show he's set for a docket call, but if it's status, maybe you can refresh my memory.
Ms. Heisel extended a revised offer this morning, and I just extended that to Mr. Elmore. And without specifically answering yes or no, or denying or accepting, he has some concerns. I think he has some friends and family that attempted to retain other counsel that he indicated to me the counsel attempted to visit with him on Friday, and they were denied entrance or visitation by the jail staff.
Well, be that as it may, Mr. Gimbel, you're the only attorney that I recognize because you're the only one that's of record. So I can't help Mr. Elmore. If he wants to hire an attorney, he can hire an attorney, and that attorney can file a motion to substitute. But at this time, I'm just going to ask for his announcement on docket call as to whatever offer has been made to him by the state, if any.
Ms. Heisel had extended offer this morning of 10 years TDC. and that was revised from last month, it was 15, and the offer now is 10, and I don't believe Mr. Elmore is interested in that.
State, do you believe that that is your best offer in this case? Do you anticipate it being revised again?
No, Your Honor. Mr. Elmore, if we prove up his priors, is 25 to life. Because of his age and some of his medical conditions, we have agreed to drop both of those enhancements. However, if we were to proceed, I just want it clear for the record that we do intend on proving up those 2 priors and making it a 25 minimum case if it goes to trial.
And Ms. Heisel, does your offer survive today if Mr. Elmore rejects it?
Judge, seeing that Mr. Elmore is currently perhaps consulting with other counsel, we would leave it open for one more setting. If he gets new counsel, perhaps that will change. However, at that point, we would be ready to move forward with the 25 to life, Your Honor.
I'm looking at his case real quick. I show that today is the second docket call announcement that Mr. Elmore has had. So we reset it from May 11th to June 1st. So Mr. Gimbel, do you have any requests?
Maybe if we could set this for one more docket call and Mr. Elmore have the opportunity to possibly retain other counsel, especially in consideration if that offer is still a viable option.
Any objection from the state?
No objection, Your Honor, and we will leave that offer open until the next docket call.
All right, next docket call is July 8th, and that will be the final docket call for Mr. Elmore. He'll either accept the state's offer or he will reject it.
Well, thank you, Your Honor. It is all I have this afternoon. May I be excused?
Yes, you may, unless Ms. Taberham has other needs for you. So I'll just ask that you check in with her before you leave. If she doesn't need you, then you're free to go.
Will do, Judge. Thank you.
Thank you, Mr. Gimbel.
Mr. Adams, are you ready? Mr. Jersey, come forward. Who's your client, Mr. Roger? Mr. Reynolds.
Who's coming up, Mr. Adams?
Your Honor, this is Levi Rogers.
CR 2191 set for pretrial. Go ahead.
Yes, Your Honor. Your Honor, I have not yet had sufficient time to complete my review of the state's discovery in this case. As to say, I haven't had the opportunity to begin looking at it yet. I've had 3 jury trials in the last 2 months, and so that's put me a little behind. And so, in addition, I do not yet have an offer from the state, and so I'm sure they haven't purposely done that. They just haven't gotten to it yet. But if you could reset us for a pretrial hearing about a month from now, I'm sure that I will have had time to do my due diligence, get the best offer from the state that they're willing to make to discuss with Mr. Rogers, so that he and I can announce to you in our next setting what we're going to do.
All right, court will set Mr. Rogers for an additional pretrial on July 8th at 1:30 if Mr. Rogers is in custody. It'll be at 9 a.m. if he is out of custody.
Sir.
And state, I would just ask that if there is going to be an offer in this case, if it can be made well in advance of July 8th, so Mr. Adams has time to consult with his client.
Yes, Your Honor, we will do that.
And they'll have an offer for me then?
Yes.
Booker and Ramirez.
Okay. Mr. Adams, are you done up here?
I've got a lady set for plea at 1:30.
Okay.
But she's out on bond. And
But she's not here yet, so you're done with the judge for now.
please with Tom, so it's gonna be 50-50 whether she goes.
Okay.
So,
Your Honor,
Yes, ma'am.
I apologize. We're not as coordinated as we normally are, but give us just a minute. We'll get back on track, sir.
Yes, ma'am. Thank you. Appreciate your help. Ms. Tabraham, are you there?
Yes, sir.
I see that Mr. Ashmore was also on Ms. Sotolo's case for a motion to revoke. Is he planning on zooming for that, or is he there today? I thought he went back. Didn't he go back?
He's
Back-
still here.
Oh, he's still here? Okay, all right. I didn't know. I thought maybe he had left after he did his
No,
wait.
he didn't get all of his people in, so he's coming in
Okay.
here in just a minute.
Okay, great. Thank you.
Mitch, I sent you an offer on Mr. Rogers. It's both in your discovery and I sent you an email.
Thanks, Tom.
Let's do, Mr. Hall, since he's right here.
Judge, we're ready.
All right, Mr. Stevens, who do
We're
you
ready
have?
on Mr. Hogg.
Matthew Hall, Your Honor.
All right, this is CR 21-103, CR 21-125, State versus Matthew Tom Hogg. And is this set for plea today?
Judge, it was, however, this plea is conditioned on my client going to Senecor, and he has not received his Senecor acceptance letter yet. And I believe, other than a plea, it was set for arraignment. So what we want to do is just do our arraignment, and then I'm going to try to get a hold of Senecor, see if I can get that letter, so we can then
Okay.
proceed with our probation.
Okay, yeah, we'll proceed with arraignment.
All right, Judge. May it please the court, my client would advise his name so correctly. He understands the nature and the consequences of the charges against him. Will waive reading of the indictment, enter a plea of not guilty.
All right, court will find that Mr. Hogg has waived the formal requirements of arraignment has plea of not guilty on each case. The court will let the record reflect that, and we will set this for a pretrial hearing on July 8th at 1:30 if Mr. Hogg is in custody, 9 a.m. if he is on bail.
All right, sir.
So we don't speak to them about that.
No, I will.
So if I get out, it'll be 9 in the morning, right?
Yeah, you're right. Don't know what I'm on here, just because it's, you're in jail right now.
Yeah.
Get your receipt.
All right, Mr. Stevens, who do you have with you now? This is Mr.
Oscar Heredia.
CR 14-220 State versus Oscar Heredia. Hearing on motion to revoke. Go ahead.
Yes, Judge, we have not reached an agreement yet. We're close. I spoke with the prosecutor last week and had a bad phone connection, but anyway, I have discussed the offer with my client, which is 10 TDC. I think that I'm going to be able to do a little better offer with him, but Judge, I'd ask you to reset it. If you need to put it on the contested docket, we can do that, but I believe it'll get worked out.
Okay, we'll put Mr. Heredia then on the contested docket on June 29th. And if he reaches an agreement, we'll take it up that day. If not, then we'll just have our hearing.
All right, sir.
And that will be at 9 a.m. on that day.
All right, sir. That's all I have ready right now, Judge.
Thank you, Mr. Stevens.
Ramirez.
Did you say this is, okay, Ms. Ramirez?
Yes, Your Honor.
CR 19-41 State versus Rachel Virginia Ramirez, or Virginia Ramirez. Hearing on motion to revoke. Yes, ma'am.
Yes, Your Honor. I just got appointed Friday, so I'd ask for additional setting. So I can get a copy of I received, I believe, a copy of the motion from the DA's office this morning, but I need time to talk to my client about it.
You mean you didn't work on Saturday,
Get an offer.
Sunday, and Memorial Day? You didn't work all Memorial Day weekend, Ms. Beasley? Is that what you're telling me?
Well, no, sir, I actually did do that. It just wasn't legal work.
I understand. All right. Are you available on July 8th?
At 1:30, yes, sir.
Well, we can do that, or we can set it on the contested docket, and that's 4 weeks from now. Do you think that'd give you enough time since this is a motion to revoke?
No, sir. July 8th will be fine if that's okay with the court.
Let me look at her motion real quick.
She has a new criminal offense that's alleged, Judge, I believe.
And what is that?
Walmart theft.
Is it felony or misdemeanor?
Judge, it's not in our county.
Do you know the level?
I believe it's a misdemeanor assault, but I don't know if it's an enhanced assault or not.
Oh, I thought she said it was a theft.
I'm sorry, Judge, I was looking at Mr. Heredia's MTA. My mistake.
It's a misdemeanor theft, Judge.
It looks like this is a 9-count in motion, so looks like there's a lot to go on here. I'm gonna go ahead and set it for June 29th, Ms. Beasley, and if there's a request for more time then I'll certainly consider that. But we'll go ahead and set it for the 29th and see if we can't get some kind of agreement on Ms. Ramirez's case, considering that there are nine counts. If it was a sole count, new offense, I would be obliged to do that, but in reviewing it, I think the 29th is appropriate.
Is that at 9 o'clock, Judge?
Yes, ma'am. Is this Mr. Booker?
This is, Judge.
CR 2105. Go ahead, Ms. Beasley.
Yes, Your Honor, this is a motion to revoke, but one of the allegations is a new criminal felony offense. It's a drug case. As of last week, the DA's office did not have a copy of the report in their office, so I'd ask for additional settings so we can get that information.
All right, court will set Mr. Booker on June 29th.
Excuse me, Judge, that's a contested docket, and this is the basis of the revocation mainly is a new offense. So I'd ask for a setting past that, that's not on contested docket.
Let's leave it on that contested date, and then if you don't have an agreement with the state by then we'll take it up on the 29th, and I'll reset it on that day. But it's a multi count. It's not a sole count motion. So.
Not, Judge, but it's a criminal case, and we're trying to get the police report. I spoke with Ms. Curry last week, I believe on Thursday, and they still didn't have the police report. I've already been working on the case trying to get it resolved, but I can't do it without a police report, sir.
Is that in Van Zandt County or is it outside Van Zandt County?
That is in Van Zandt County. It took place in Wills Point.
Let's see if the state can get it done. Let's see if the state can get that report to you by then. And what I'm telling you, Ms. Beasley, is if 629 comes and you don't have it, then you'll tell me that and I'll reset the case.
Yes, sir.
But if you get it next week and y'all can be prepared or you can resolve it on 629, then that's what I would like to do. I mean, it's 4 weeks. I mean, it's 4 weeks from today.
Okay, Judge. I just like to try to be prepared for court.
I know. And I'm telling you, if you're not prepared, I'm going to reset it. I'm not telling you I'm going to hold you over for a contested hearing. I'm just going to put it on the contested docket.
Okay, Judge. May I be excused, Your Honor? That's the only two cases I have on the docket.
Yes, ma'am.
Okay, my bad, I apologize.
All right, Mr. Sanders, who do you have with you?
Mr. Hanstard.
All right, this is CR 2339, State versus Norman Wayne Hansard, set for docket call. Go ahead.
And Judge, I was just appointed about a week and a half ago on this case, substituting in for Mr. Gimbel. And so we're not ready to proceed with it. I'm just asking for some more time to meet with Mr. Hansard and prepare the case.
Okay. And this is not a motion to revoke, is it? This is a new case, I believe. Is that correct?
It should be a new case.
Yes, Your Honor, it's a new case.
All right. Are you available on July 8th for pretrial, Mr. Sanders?
Yes, that should be fine.
All right, court will set this for pretrial and give you a chance to review the evidence. We'll set it July 8th at 1:30, 9 a.m. if Mr. Hansard makes bail in the case.
Thank you.
And Mr. Sanders, before you leave,
Judge.
let's go ahead and take up Mr. Key. Mr. Key's been found incompetent, is that correct?
That's correct, Judge.
And
they didn't.
Go ahead.
Judge, I was just gonna let the court know, I think they were planning to bring him into the courtroom, but I think they were having some issues with Mr. Key, so I just said just to wait. I don't think there's really a need to have him here.
That's what I was going to ask you. If you will, or if you are wanting to waive the appearance of your client, then the court would approve that. This is CR 253, State versus Joshua Daniel Key, based on the expert finding that he's incompetent and the court issuing an order for him to be committed to the state hospital for competency restoration. Ms. Taberham has given us a note here that he's number 165 for a bed at Terrell State. So considering that, let's just set Mr. Key on a status. We'll just call that a commitment status, mental health commitment status. And we'll set that out 60 days. Let's look at, are you available on July 27th? Or if I've given you any dates in late July, tell me what you have.
No, I don't believe I have any, Judge, that late, so the July 27th should be fine.
All right, let's set July 27th for a status for Mr. Key, and then we won't bring him up. Did you meet with Mr. Key at all today, Mr. Sanders?
No, I haven't yet. I thought I would still try to go talk to him and give him a copy of the notice at least.
Okay, all right. And if there's any issues, just let me know. I'll help you where I can.
Okay. Oh, okay. Thank you, Judge.
Is that all you have, Mr. Sanders?
Mr. Harrell, but he hasn't been brought in yet.
And who is that? Okay, is it a new appointment today? He's a writ. Okay, he's at the end. Okay, there, I see it. Okay. Thank you, sir. Ms. Abraham,
Yes, sir.
do you have any of the defendants who do not have attorneys? Have they received court-appointed attorneys? I see that Mr. Bobby Montgomery had Mr. Schmidt appointed on 5/28. What about Mr. Bolt, Perez, Watson? Any of those received court appointments?
Perez, you signed this morning, and we gave him, Jonathan.
Mr. Manning? Okay.
Mr. Manning.
What about Larry Watson?
Mary Watson got Mr. No.
No, okay. And what about Bolt?
I
Jason?
must have overlooked. I must have overlooked him, so let me go see if I can talk to him.
Okay.
And then Mr. Stevens is ready
Oh, yeah, Candace.
on Candace Smith.
Okay. Come on up, Mr. Stevens.
Oh, that's it.
All right, this is CR 2368, State versus Candace Kalen Smith. Set for docket call. Mr. Stevens, go ahead.
It is, Your Honor. We're going to ask for one more docket call. Miss Smith missed court in April. She had a seizure, medical emergency, missed the court. She's now finds herself back in the jail. I think we're going to be able to work this out. I do have an offer, 12-month state jail offer. I do believe we're going to work it out, Judge. But if we could do another docket call without it going to the trial docket, we'd really appreciate it.
Any objection from the state?
No, Your Honor.
And so, Mr. Stevens, you're not saying that she's accepting the offer. You're saying you're just telling me what the offer is and that you think that y'all be able to work it out. I'm saying that's you're accepting.
Yes, yeah, it's exactly what I'm saying, Judge.
Okay.
Yes.
All right. Court will set a final docket call for Ms. Smith on July 8th. And on that date, I'll just need to know if she's going to accept that or a counter offer or she's going to reject it. But that'll be the final time.
All right. Thank you, Judge. That'll conclude my business, Judge. Might be excused.
Yes, sir. Thank you. And I actually check in with Ms. Abraham before you go. Thank you, Ms. Smith.
Yes, sir, thank you. All right, Mr. Adams is ready on the plea on Katie. Yes.
All right. All right, this is CR 16267, State versus Katie Ann Risky. And what are the terms of the plea? I don't have any plea papers before me.
That's fine. I have them right here, Judge. In exchange for Ms. Rescue's plea of truth to the allegations in the state's motion to adjudicate, her guilt will be adjudicated, community supervision will be revoked, and she will be sentenced to 9 months state jail facility. Balance of financials.
Credit time? How much credit time does she get on towards her sentence?
4 whole days.
4 days.
Yes, sir.
Any cases being 1245 are taken into consideration with her plea today?
No, sir.
Okay. All right, Miss, it's Risky, correct? Is that how you say it?
Yes, sir.
Okay. Ms. Risky, will you raise your right hand? I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
May I put your name down? Make sure you speak up loudly and clearly so my court reporter can hear you. Ms. Riskey, you appeared before the court, and I'm having displayed on the screen here the state's motion to adjudicate, which was filed on, it appears to be December 5th of, say, 2017, perhaps. Let's see. We may have a problem with this one, Mr. Adams. Mr. Adams.
Your Honor, I would stipulate that it was filed December 5 of 2017.
Yeah, I see we may have a problem here, though, if you'll look up. So it appears that
Yes,
I've signed, I may have acted as the prosecutor in this case,
Yes,
if I've
Your
got
Honor.
the correct case.
You are correct. In that case, Your Honor, I think it's incumbent upon me to ask that we halt today's hearing, and that I'm going to ask for a visiting judge to preside over the proceedings and ask that you agree to recuse yourself from further proceedings in this matter.
Yes, sir. Court will find that it did act as a prosecutor in this case for Ms. Riskey, and that the court did, as an attorney practicing in the Vance County Criminal District Attorney's Office, did sign the motion to adjudicate, and therefore would be disqualified under the law for serving as the judge in this matter. So that being the case, Ms. Riskey, what I'm going to do is going to reset your case and apologize for any inconvenience. Had I known that this was the case beforehand, I would have made an arrangement for another judge to hear this case. So you're going to, and we can talk about what we do here today. We can either reset this case, or, the court could find her bond insufficient if you wanted her to go ahead and go in and start getting credit towards her sentence, if that's what she planned to do today. I don't know if you want to talk to the state about that, but otherwise.
We have a moment to.
Yes, please do. Let me recall your case, and I just know there's a lot of moving parts here, and let's take a moment, and then you let me know when you're ready.
That's fine, Your Honor. And I have difficulty recognizing my signature and other people's signatures, so I didn't snap to the fact that this was yours. It just.
No, I'm glad I looked, though. I'm glad it's my policy to always pull those up and read those, so I'm glad I did in this case. So.
Yes, sir. Me too. Okay, we'll go powwow and let you know how to proceed.
Yes, sir.
Thank you. Judge, we have Mr. Sanders and Mr. Harrell.
Okay, bring them up. I'm gonna, stay where you're at, right there. I'm gonna be just one. All right, Mr. Sanders, I believe this is writ number WR 2131 and 32. And is this a writ seeking bond reduction or probable cause determination?
It's seeking bond reduction, Your Honor.
Okay. Are you going to call your client today?
Yes, Your Honor, just for the limited purpose of this hearing. And Judge, we just point out there are two charges. Total, I think the bond amount is $180,000 between the two. And as far as I know, neither case has been indicted at this point. And I'm not sure if the state has received a copy of the case or cases at this point. But just for the limited purpose of this hearing, I would call Justin Harrell. And Mr. Harrell, first of all, just state your name.
Well, hang on, let me swear and put him under oath. Mr. Harold, raise your right hand. Sir, do you swear that the testimony you give to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, Chambers.
Thank you, Judge. Justin, just for the limited purpose of this hearing, I have a few questions concerning your bond situation with these two cases. You were arrested February 22nd of 2021, is that correct?
Yes.
And it's for the charge of endangering a child and aggravated sexual assault of a child, is that correct?
Yes.
Okay. And to your knowledge, have you been given any notice at all that either case has been indicted at this point?
No, I have not.
And have you been in jail this entire time since February 22nd?
Yes.
And I believe I told the court that the total bond amount is $180,000. Is that your understanding?
That's the way I understand it from day one.
Okay. As far as your financial situation, do you have any, or how much cash do you have? How much money do you have that you could pay towards a bond to bond out?
None right now. None right now. Me and my wife are really struggling for our monthly income, and it's really hard.
Okay, especially because you're not out to.
Yeah, not out to, help her.
As far as any automobiles, y'all own any automobiles?
We've got one right now that is running and it's still being paid on.
Okay, so you don't own it outright?
No.
Okay.
I do have two that I do own outright, but neither one of them are running.
Okay, do you know what the value of those might even be?
Probably not even under 1,000, probably a piece.
Okay. As far as where y'all live, do you own your own home?
Yeah, we own our camper.
Okay. Do you know what the approximate value of that is?
With the way it's looking, it's probably $50, $75.
Okay.
It's leaking.
Okay.
And
okay.
it's just right now we're using it as just a temporary roof over our head.
Okay.
Until I get out. My wife's talking about wanting to move into a hotel or something.
Okay. In terms of being able to bond out, if the judge, or basically you're asking for the judge to grant you a PR bond today, is that correct?
Yes.
Okay.
If possible.
Just based on your financial situation, even if the court lowered it a significant amount, basically it would have to be very low for you to be able to even pay something to bond out. Is that what you're saying? Okay.
It would either have to be really, really low, or they would have to more or less work with us until next month.
Okay. If the total amount was reduced to $10,000, is that something you think that between your wife and other family you might be able to?
Might be able to.
Okay.
I'm not gonna guarantee that on anything.
Okay. You're always asked the witness.
State, any questions?
Just a few, Your Honor. Mr. Harrell, are you aware of who the alleged victim is in this case?
Yes, I am. And my granddaughter, it's my granddaughter.
Oh, it's your granddaughter. Okay.
Yes.
Okay. And Mr. Harrell, if you were released, where does she live in relation to you? You don't live on the same property, do you? Or do you?
No.
Okay. And your camper that you own, where is that currently located? Is it here in Van Zandt County?
Yes, on County Road 2117.
Okay. And how, you have one operational vehicle, is that correct?
Yes, ma'am. And that's the one my wife's paying on every 2 weeks.
So you do have transportation to come to court?
Yes.
Okay. And Mr. Harrell, if you were to be granted release, would you be willing to agree to an ankle monitor for GPS just to make sure that there was no contact with the alleged victim in this case?
Yes, ma'am.
Okay. And there is some financial cost associated with that. Would you be able to come up with the financial cost to make that happen?
I would definitely try my best. More than likely I'll be able to.
Your Honor, we have passed the witness.
And Mr., the financial cost with ankle monitor is about $300 a month. Is that something you believe you could afford?
Yes, Your Honor. With both of my checks that I draw a month from Social Security,
I draw a little over 800, so if I had to bind down to, pay for something like that, knowing it's to better me, then yes.
Mr. Sanders, any follow-up?
No, Your Honor.
Any other witnesses or evidence, Mr. Sanders?
No, Your Honor, that's all we have.
State any evidence, witnesses?
No, Your Honor, just for argument.
All right, go ahead, Mr. Sanders.
Judge, just based on the fact it's been well over 3 months now, cases have not been indicted, and as I mentioned before, I'm not sure if the state even has the reports yet. And Judge, I believe based on his financial situation, under these circumstances, I believe that a PR bond in each case is the appropriate and just resolution.
Thank you, Mr. Sanders. Ms. Heisel?
Yes, Your Honor. We would stipulate that it has been more than 90 days without an indictment. Mr. Sanders is correct that our office has not yet received a case from the arresting agency. However, Judge, I do not believe that a PR bond is appropriate in this case. Mr. Harrell's testimony is that he does have some assets available to him. He does have monthly income in the form of disability checks or some kind of assistance checks from the state. And we do believe that he does have some means, therefore a PR bond is not appropriate. We do understand that a bond reduction is required by law, but we would ask for a $25,000 bond, cash or surety, with no contact conditions on those. We would not request GPS at this time. However, in the future, we reserve the right to come back and re-ask the court for that condition.
All right. All right, then based on the facts and evidence as they've been presented to the court does find that Mr. Harrell has been continuously confined for over 91 days, that an indictment has not been returned in either case. Court finds that based on the testimony provided by Mr. Harrell that he does not have the financial ability to post a bail in this case and also provide for the necessities of life. So the court's going to do is I'm going to grant a $10,000 personal bond in each case. Court is going to enter conditions of bond requiring Mr. Harrell to report, to pay a supervision fee, to pay attorney fees. Court's probably already applied conditions of pretrial release to Mr. Harrell. And if I have, I'm going to have that amended to include the monitoring by a GPS device. The court finds that it would have more comfort for the alleged victim safety for GPS monitoring than it would for the financial commitment to a bondsman. So the court's going to enter that as a condition of bond, and Mr. Harrell is not to be released until he pays for that GPS device and it's placed upon him. So I will sign that and get that sent over to the jail today, Mr. Sanders. All right, anything further, Mr. Sanders?
No, Your Honor, that's all we have.
All right, thank you, sir.
Thank you.
All right, Mr. Schmidt, good afternoon, sir. Is this Tessifer?
It is, Judge.
All right, this is cause number 2019-423 and CR 21-124. Show that we're set for pretrial in the former case and arraignment in the latter case. Is that correct?
That's correct, Judge. On the 2019 case, we don't have any contested pretrial for that case. On the CR 21-124, that is an arraignment.
we received the indictment. I've got, I believe, to be most of the discovery. There's a few things that I'm gonna have to talk to Ms. Curry about, but as for today's purposes, we'll wait formal reading of the indictment. Her name is spelled correctly. We enter a plea of not guilty, ask the matter be set for pretrial.
All right, CR 21-124, court will set Ms. Furr for pretrial on July, be available on July 8th, Mr. Schmidt?
I don't think so. I think I'm out of town. Hold on one second. Yeah, I can make the 8th, Judge.
Okay, well, let's go ahead and set both cases. We'll just set up for pretrial. I understand you don't have any pretrial motions in the misdemeanor case, but just go ahead and keep it even. Let's just continue it on a pretrial at this time for July 8th in each case.
Yes, sir.
Who do you have now, Mr. Schmidt?
Judge, this is David Ford, CR 21-00116.
All right, and I have arraignment / plea.
That's correct, Judge. We are set for an arraignment today. We have reached an agreement with the state, which we are going to accept. There are a few matters, and I've got the paperwork, but there are a few matters that Mr. Ford needs to take care of before he does that. Basically, we're accepting a plea for 5 years TDC. We'd ask that we be allowed to take that plea in July.
Mr. Ford is going to remain.
Yes, sir.
What does he have to do?
I'm sorry, what's that?
It's all right, the internet's kind of really delayed. What does Mr. Ford have to take care of before he can accept the plea agreement?
Judge, we're going to get some paperwork done to make sure that his affairs are in order. He will be going to TC. We've got a lot of it tended to, but basically that's about it. We will be ready to take the plea.
Has Mr. Ford, I show that he's got some jail time credit. Has he been in our jail for 235 days?
He's been in for quite a while, Judge. That's the credit I see on his judgment. So I presume that's all been on this case.
I understand the request. My only concern is that if he's been in jail that long, and we have an agreement, I'd like to go ahead and go forward with it today if I can.
Well, I understand, Judge. If I could, I mean, we are just set for an arraignment today, so he hasn't been arraigned on these charges. Obviously, I'd like to get it resolved as well. If I could have a minute to talk to Mr. Ford, and then we can recall this case here in a minute.
Yes, sir, if you don't mind.
That's okay with the court.
Yes, sir.
All right, thank you.
Mr. Atkins, do you want her in the courtroom?
Right.
All right, let me get back over here. All right, we're back on the record, CR 16-267, State versus Katie Ann Risky. Mr. Adams, have you had an opportunity to speak with Ms. Risky to see if there's, what's the defendant's request today?
Yes, Your Honor. Ms. Risky and I have talked about the pros and cons of the two ways that she could go, either waiting until our next hearing date or surrendering her bond today. It's hard for me to second guess her. She's decided that she does not want to go into custody today. She would like to remain on bond until we can come back for a final hearing. She advises me that she still has some personal matters to attend that she would like to attend to regarding her abode and her belongings and that sort of thing before she goes into custody. And if the court has any second thoughts about her decision, I would just point out that we set her We set her about, was it 3 or 4 weeks ago, we set today's hearing in the past, knowing that when we were coming today, that we were going to be entering pleas of truth time in exchange for time. So I have every confidence she'll show up, because she has a track record of showing up already.
Sure. Did she not take care of her personal affairs before she came today?
I'm still working. I'm still doing it. I have an apartment and have other things, and I have a job and all those things.
She's done some, but not all.
Not all.
What I was anticipating doing, Mr. Adams, was filing my motion to recuse. I think there's probably a strong likelihood that Ms. Risky would be assigned to the county court of law with Judge Winters, and I believe that they have dockets this week. So, say that again.
Well, Your Honor, I will not be available the rest of this week. I am leaving town. My son graduates from high school tomorrow, and that's taking place at Westbrook and Beaumont. I'm going down to the 409 area code tomorrow for that, and expect that I won't be back until Friday morning.
Okay. Well, let's, let me see here. Let me look at mine.
Judge Winter's calendar shows that Monday the 7th is his next criminal docket downstairs, Judge. Next Monday and next Wednesday.
Yes, thank you. Yes, Miss Barker, she's been chatting with me in here. She's got that date lined up. So let's do this. I'm going to set Ms. Risky then to appear in the county court of law to enter her plea on Monday, the 7th.
Judge, I hate to derail it, but I have a final pretrial hearing set in Cherokee County Monday morning at 8:30, and another final pretrial hearing in Cherokee County that same afternoon. And I am tentatively, I have settings in Cherokee County on the 9th also.
All right, give me just a moment. I'll be right back with you.
Yes, sir.
All right, Mr. Adams, what I'm going to do is I'm going to just set Ms. Risky then for July 8th, anticipating that she's going to get a notice from the county court of law as to whatever date they tell her to be there. I don't know when that's going to be. So that's just what we'll do. I'll set her just for a status on plea, or I'll do status on plea and recusal on July 8th, just so we know it doesn't fall through the cracks. And then if Ms. Risky gets a notice from the county court of law to appear before then that will alleviate her from having to appear here on the And I'll get the motion to
Yes,
recuse
sir.
signed and sent over to my regional judge this afternoon.
Very good, Judge. Be an afternoon setting on July 8th if it's needed.
No, it'd probably need to be morning because she wouldn't be on my jail docket. I that she's going to get a notice from Judge Winters or whichever other judge is assigned. I'm confident it'll be Judge Winters, but if not, then Ms. Abraham will send out a new notice. So let's just say July 8th and
Until further notice, until we hear from Judge Winters, it'll be July 8th at 9 o'clock, or until we hear from Judge Winters to the contrary.
yes, sir, exactly.
Okay, very good. Okay. All right.
All right, you're free to go, Ms. Risky.
Are we off the record, Your Honor?
Off the record, but not off public record.
That's fine. I'll leave my pants on. I'll be a little proactive. Since I don't want things to take any longer than necessary, but I also don't want to counter conflict. So I might just reach out to Miss Anthony in the Winters Court to see what we might be expecting so far as upcoming court dates.
I think it may be July 7th, potentially the day before.
Okay.
Potentially, but yeah, check with Anthony. And yeah, I got to the point where we couldn't really figure out, and I think they were going to make they were going to move some things around for us to accommodate us. But your schedule, graduation, those things, I think it's better just to let them have the case. And this is all contingent upon Judge Charles assigning the case to Judge Winters. But if he doesn't have a conflict, that's typically what occurs.
All right, very good. I'll get on it. Thank you, Judge.
Thanks, sir. Appreciate you.
Yes, sir.
We're ready on Brian Kronberger with Jeff Wood.
All right. All right, court call CR 20395, CR 224, State versus Brian Scott Kronberger. And Mr. Kronberger, if you'll raise your right hand, I'm going to place you under oath, sir. But Mr. Kronberger, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down.
Yes, sir.
Make sure you speak up loudly and clearly for me. Mr. Kronberger, your name is Brian Scott Kronberger, is that correct?
It is.
Mr. Kronberger, are you a United States citizen? Do you read, write, and speak English?
Judge, can I stop you real quick?
Yes.
I know the case was, it sounds to me like you're going forward on a plea. Judge, I've been talking to Mr. Kronberger. My intent today was obviously to resolve this case by way of a plea. There are a couple questions that Mr. Kronberger has for me that I feel like I need to answer in a little bit more in depth. And I think that based on the nature of the plea offer, which is a very good plea offer, but kind of what Mr. Kronberger could be facing and those kind of things, that he's asked that I just ask for one more status regarding the case and the plea. So if we could have to June 29th, my intent at that point in time, Your Honor, will be to answer any questions that Mr. Kronberger has regarding the cases against him, make sure he understands completely, and to either announce to the court that it's going to be a plea or that it's going to be a trial. And I have no doubt about it in my mind that we'll be able to make that announcement on June 29th. Hopefully, maybe even if it's going to be a plea, we can resolve it before that time.
Is the state joining you in that request?
Judge, we're unaware of any communications between Mr. Kronberger and Mr. Wood. State would take no position. We're not in opposition, but we take no position on this.
So you're not objecting to his request for more time?
No, Your Honor.
And I'm sorry, Mr. Wood, it was written on my docket plea, and I had judgments here, so I just assumed that that's what we were doing.
And that's my apologies, Judge. We were, like I said, I think we were set to go. I had actually talked to Mr. Kronberger on Sunday a little bit, and he just kind of brought up some additional questions for me this morning that I think, like I said, I think it's beneficial for him more than anybody that he understands exactly what it is. Obviously that he's going to be, it's not even about pleading guilty to it. It's more kind of collateral things that are going on as well. So I think we can answer all those questions for him and get something done on the 29th, one way or the other.
All right, since there's no objection by the state, the court will set this for a final docket call on June 29th. That's going to be at 9 a.m., Mr. Wood. It won't be at 1:30.
That's fine, Judge.
Okay, and I'd also just bring y'all's attention to this judgment I had sent over on unlawful possession of firearm by a felon said third-degree felony, but it also said 12 years confinement in TDC. So I was going to have to ask about that anyway. So it appears to be an illegal sentence on that charge.
The initial, the indictment, Judge, is actually an indictment that contains 2 enhancement paragraphs. State is going to be abandoning one of those paragraphs in each one of those cases. So we'll have the judgment reflect that.
Okay, yeah, because there was no finding of true or allegations of true on this either. So, all right, Mr. Crum, you're going to get one more setting, and that's it. 6/29. You don't have an agreement on that day, then I'm just going to set you for trial, and whatever the state moves forward with is what the jury will be submitted to the jury. You understand?
Understood.
All right, we'll see you on June 29th.
Thank you, Your Honor.
You're welcome. Oh, I can't do this. But I can't do it because I was disqualified. So I can't assign it to anybody. It has to go to Judge Charles. It has to be, yeah, because I was disqualified as the prosecutor.
Okay, so I'm gonna. Okay. I still have him.
Yeah, he's the one we got recalled on here.
All right, Mr. Manning, is this Mr. Zimmerman?
It is, Judge.
All right, court call CR 2374-375, State versus Michael Cody Zimmerman, set for a docket call in each case. Go ahead, Mr. Manning.
Is we're ready to proceed and move to the jury trial docket.
All right, and can you just, for the record, tell me what offer it was that the state made that the defendant has rejected, if any?
I believe the last offer we had was 60. I don't know. There may have been an intervening offer since then, but 25 was the last offer we received and discussed. My client rejects that offer.
So there was a 60-year offer and a 25-year offer, or two 25-year?
Originally, there was a 60-year offer. There was a 60-year for both, and then he rejected that. We got a 25 offer for both, and he rejected that.
Okay. State, do you believe that you have made your best and final offer in this case?
Your Honor, it's hard to say. Our victim is currently in jail in another jurisdiction with problems of her own. We've been unable to contact her due to that. I believe at this point that will be our best offer. But I can't say dispositively, Your Honor, until I have a conversation with her.
All right, court's going to set Mr. Zimmerman for jury selection. And we will begin jury selection process. We'll place him on for June 7th. Mr. Zimmerman, your attorney, Mr. Manning, is not going to be required to visit with you on each jury selection docket. He will not be required to appear before the court on jury selection until your case is set in the court's top 10 and that he is noticed for trial. If you make bond in this case, Mr. Zimmerman, you're ordered to appear at the Van Zandt County Courthouse at 8:30 on June 7th. And my staff will meet with you to issue a new date. If you're in jail and your case is not reached for trial, then the court will reset you for the next jury selection and we'll send you notice of the next date. All right, this is cause number CR 21-86187, State versus Courtney Michelle Odom, set for docket call. Go ahead, Mr. Manning.
Yes, Judge, we're ready to proceed and we set on the jury trial docket.
All right, and for the record, what was the offer, if any, that your client has rejected?
I received an offer from Ms. Curry this morning for 10 years TDC.
And your client rejects that?
That's correct, Judge.
And was that 10 years in each case or just one case?
She didn't specify, Judge.
Okay. All right, and Ms. Odom understands that court may not entertain a plea agreement after today's date?
Yes, Judge, we've discussed that.
Okay. All right, court's going to set Ms. Odom for jury selection on June 7th.
Anything else, Your Honor?
Nope, that's all.
Okay.
Mr. Schmidt is back with David Ford.
All right, just one moment. All right, Mr. Schmidt, back on the record, CR 21-116, State versus David Ford. Have you not had an opportunity to discuss with your client what he wants to do today?
Yes, Judge, we have, and we're prepared to proceed with the plea.
Find it here. All right, let me read to you, Mr. Schmidt, and you, Mr. Ford, what I believe the plea agreement to be, that Mr. Ford's going to plead guilty to driving while intoxicated third or more in exchange for the state's recommendation of 5 years confinement, TDC, $1,500 fine, $60 restitution, $20 reimbursement fee, $290 court cost, 235 days credit towards his sentence in this case. Is that right, Mr. Schmidt?
That is correct.
All right. Mr. Ford, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? And you have to speak up. I can't hear you.
Yes, Judge.
Okay, thank you. Put your hand down. Mr. Ford, your name is David Richmond Ford, is that correct?
Correct.
And Mr. Ford, are you a United States citizen and do you read right?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Excellent job.
Do you feel like you've had enough time to discuss your case with him and have all of your questions answered?
Yes, I do.
And Mr. Schmidt, do you believe Mr. Ford to be competent today?
I do, Judge.
And you've explained to him all of his legal and constitutional rights?
I have.
All right, Mr. Ford, you've been charged by indictment with a third-degree felony offense of driving while intoxicated third or more. It carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, I do.
Court finds that the proposed plea agreement fits within the lawful range of punishment. At this time, Mr. Ford, how do you plead to driving while intoxicated third or more alleged to have been committed on October 9th, 2020?
Guilty.
And Mr. Ford, are you pleading guilty to that, but you are guilty of committing that offense?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to States 1?
No objection.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing further.
All right. Mr. Woodwhite, can you give the court, I think all I have here is a judgment. I don't have States 1. Can you give me evidence to support the plea?
Judge, on the date in question, DPS trooper was called out with multiple 911 phone calls for a intoxicated driver on the I-20 rest area near Van. The defendant drove the wrong way up the one-way exit ramp of I-20. Mr. Ford admitted to consuming many alcoholic beverages. He was at the rest stop trying to sleep off his intoxication, but he needed to go get more. He refused to provide a specimen. Yeah, this court signed a blood warrant for him, and I believe the results of which are 0.258 BAC.
Mr. Any objections to the summary of evidence?
Judge, I think this is substantially correct. No objection.
All right. Then based on the evidence before the court finds that there is sufficient evidence to convict Mr. Ford of this offense, and the court does follow the plea agreement in this case, convicts Mr. Ford of driving while intoxicated, third or more offense. Court assesses his punishment in accordance with the plea agreement at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a $1,500 fine, orders payment of restitution in the amount of $60, reimbursement of $20, court costs of $290. Court also awards Mr. Ford 235 days credit for the time that he has spent in jail on this cause. Mr. Ford, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, sir. All right, Mr. Schmidt, who do you have left? Horton, and also, do you have anyone else ready?
Yes, Judge, I have Bobby Montgomery. It's my understanding that Mr. Horton has refused to participate in this afternoon's proceedings, so they did not bring him up. I know he's set for an arraignment. We're gonna have to file some motions on Mr. Horton's behalf here shortly.
Okay.
Attendance in the-
Let's go ahead and go on record
But
then.
Mr.
Yeah, let's go ahead and go on record. CR 21-126-127, State versus John David Horton, set for arraignment today. Court finds that Mr. Horton refuses to participate in the arraignment proceeding today. Court will reset arraignment for Mr. Horton on the basis of Mr. Schmidt's representations to the court. And we will reset that arraignment to, did I give you July 8th earlier? And did you say that was okay, or?
You did, July 8th, Judge.
Okay, well, let's go ahead and set Mr. Horton then for arraignment on July 8th, and we'll see about your motions between now and then.
So,
All right, Mr. Montgomery?
yes.
All right, this is CR 1428, State versus Bobby Ray Montgomery Jr. Court finds that Mr. Montgomery requested court-appointed counsel. Court reviewed the application in indigency. Court finds him to be indigent, has previously appointed Mr. Richard Schmidt as counsel. Mr. Schmidt, have you had an opportunity to speak with Mr. Montgomery about his motion to revoke?
No, Judge, I haven't. I think I received the appointment Friday afternoon. I haven't had an opportunity to speak with him about it. Also, Judge, I think that there's another issue that I need to look into. I'm not certain. I do realize it's a CR 14 date. I got to look at, I haven't seen the judgment. I've requested that the state open that up for me on their portal so I can see whose name on it. I'm sure you have access to that. It might be a problem.
I'll tell you what, give me just 1 second and we'll look at that together. System was real sluggish today. Kind of like me.
Judge, Mr. Schmidt, I was about to say, Mr. Schmidt's name does appear on the original judgment.
So that guy. That's true. Okay, so you can launch an objection to my. Well, that's true. It's not about whether or not it's whether or not you object to that. In that item was on your judgment. So, in other words, if you say it's good, then you can't come back and say, I want to do it because of this way. So you're aware of the potential. And then also be honest because it's better.
So the motion was signed by you, Ms. Heisel, correct?
That's correct, Your Honor. It was just the original judgment in which Mr. Schmidt's name appears. I've reviewed our internal file. I don't see any other notations with his initials on them. So I have no evidence that he had any substantial interaction with this. Both him and Miss Flanagan's names appear. So I had just assumed that that was done as a general matter, of course. And so the state would have no objection to moving forward.
And Judge, I've spoken with Mr. Montgomery. He, as of today, has no objection to moving forward with me on it as well. So we just asked to be reset, have me an opportunity to speak with him and speak with the state on that.
Okay, and I'm gonna just go ahead and display this as well. Looking at the written plea admonishments, it looks like Ms. Flanagan may have been the lead prosecutor on that case back in 2014, so. Okay. All right, so there being no objection from the state and Mr. Schmidt, what did you say? Did you say that Mr. Montgomery waives any potential conflict as well?
That's correct.
Okay, all right, then the court will set Mr. Montgomery for, let's set Mr. Montgomery on June 29th, Mr. Schmidt, with the understanding that you've recently been appointed. That is the contested docket date. However, if you and the state have an agreement not to go forward that day, or if you don't, then the court will certainly consider any requests for reset if you need additional time.
So that's fine.
Any conflict on that date?
No, Judge, that should be okay.
Okay. And that'll be at 9 a.m.
I understand. Thank you. At 9 a.m. on the contested docket?
Yes, contested docket
9
start at 9 a.m. Contested docket start at 9 a.m. and we have the inmates brought over
Okay.
typically for their hearings.
Okay, we're to Mr. Manning and
Perez.
Mr. Perez.
Okay. CR 19-272, State versus Joshua David Perez. Hearing on motion to.
Yes, Judge.
I'm sorry, I couldn't hear that. Mr.
Yes, Judge, I got appointed Mr. Perez this morning. I received the motion to revoke. I reviewed that, spoken to my client about that. I've entered into conversations with the state to see if we can get some information, get his case resolved. I would like to get his case reset at this point in time and see if we can get it taken care of in the interim.
All right, court will set Mr. Perez then for the contested docket on June 29th. If there's no resolution by that date, we'll either have a hearing or court will consider a request for additional setting.
Judge, will that be on the 1 o'clock docket?
No, sir, that'd be 9 a.m.
Will the inmates be brought over to the courtroom?
Yes, sir.
There's a conclusion of business, may be excused.
Yes, sir. Thank you, Mr. Manning.
Thank you.
Ms. Abraham,
Yes, sir.
any Bolt, Jason Bolt, any appointment?
Mr. Bolt informed me that he is retaining Nolan White within the next week. He's been in conversation with him, and I think it's to pay him by Friday.
Okay. Is he in the courtroom?
No, not yet.
Okay.
So I think we're down to just Casey's, Ashmore's, and then Mr. Bolton.
Mr. Knoll's not here today. We'll need to reset that. Mr. Abraham,
Yes, sir.
on Larry Watson, we appointed Mr. Knoll today.
Yes, sir.
Are you aware of when Mr. Knoll may be coming back? Do you believe I can set that on the 6/29 docket? I'll tell you what,
I do not have.
let's just do a notice of appearance for Mr. Watson for him to be placed on the contested docket 6/29. If you'll just let him know or have jail staff know that Mr. Knoll has been appointed, make sure he has contact information for Mr. Knoll, then we don't need to bring him up.
And then on Mr. Harrell, I believe Ms. Burns has sent the PR bond paperwork to Waynet.
Yes,
The
I have it.
conditions, I'm sorry, to Waynet. Okay.
Yes, yeah, I'll get him signed here in just a minute. I'm looking at also on Mr. Bolt. He said that he believes that he can hire Mr. White by Friday.
Yes, sir. Yes, sir.
Let's just go ahead and set Mr. Bolt in for another arraignment on July 8th. Mr. White is scheduled to be back on that date if he does get hired. Otherwise, he'll just need to have someone hired. So we'll just reset arraignment today to July 8th. And you can let him know that he needs to communicate that to Mr. White. No need to bring him up for that.
Okay.
So that should just leave us with Mr. Sotelo and Mr. Ashman.
And Mr. Hobson.
Mr. Who?
Hobson, Mario Hobson is Mr. Ashmore's. He was not able to see all of his defendants this morning.
Oh, he's not doing the waiver on Mr. Hobson?
No, sir. Are
Okay,
you ready for Mr. Ashmore?
yes.
Judge, did Mr. Crawford file waivers of arraignment on Shelby Newton?
Yes. They're not on today's docket, but I do remember seeing those and signing those. I'm not sure what the date is, though. I'd have to look that up. It'd be in the clerk's case. Mr. Ashmore, are you
I am, Judge.
ready on, who are you ready on, Hobson or Sotelo?
Let's bring up Mr. Hobson.
All right, Mario Hobson, CR 21-123. Mr. Hobson is set for arraignment today. Have you had an opportunity to review the indictment with him?
Yes, Judge, it's a first-degree felony conspiracy under the Health and Safety Code. He understands the range of punishment is 5 to 99 years. His name is spelled correctly on the indictment, and he has authorized me to enter a plea of not guilty and continue working with the district attorney's office on a plea recommendation. At this time, there is none. There has been a substantial amount of discovery turned over in this case. We don't know if there will be a need for any discovery motions. We're asking the court to allow us to reserve the right for an additional 3914 motion if we learn something later that we need to ask the state for. Also, Mr. Hobson was originally held on two $100,000 bonds, which are for charges that are rejected or not being. So we're asking the court for a $10,000 bond on this matter, which we understand he has the financial ability to make.
All right, you got to back up on that. Is there a motion to reduce bond that's been filed with the court?
It hasn't been filed as of yet, Judge, but since the original hold was for these two different charges that have been rejected, and now it's just a conspiracy, maybe I'm making an improper guess, but I thought the court might be setting a bond on this charge today, and we're making that, at least that oral motion. And if I need to back it up with a written one, I certainly will, Your Honor.
Well, the state's entitled to notice on any motion requesting any kind of relief from the court, but what is his bail set in this case? You said that I was going to be setting bail today. Does he not have bail in this case already?
Well, not on this charge, Your Honor. There's these two other charges that he was arrested with regard to, which, as I understand, have been rejected, and now this conspiracy charge remains.
Judge, we did do an after indictment warrant. I'm trying to pull it up in the clerk's side now, but I would assume that there was a bond set with that after indictment warrant. If you'll give me just a second to pull it up. Judge, I see that the warrant was issued, but I don't see that a bond was ever set on.
All right, this is a first degree felony offense, range of punishment 5 to 99 or life. And Mr. Ashmore, you're asking the court to set a $10,000 bond, and you said his previous bonds were set at 100,000, and those cases were rejected by the DA's office?
That is my understanding, Judge.
State, you concede to that?
Judge, I wouldn't say that they were rejected. I would say that the criminal conspiracy charge was filed in lieu of what he was originally arrested for. Upon review, we believe that was more appropriate. We would ask that the $100,000 bond be carried over, since it did all arise out of the same course of conduct. It's just simply calling it something different on the indictment. But Judge, we're not really prepared to go forward with the writ hearing today, but that would be the state's request.
Right. The court reviewed the indictment in this case. The court is also familiar with issuing the warrants of arrest in the previous cases. So I am familiar with the alleged facts up until this point, based on the affidavit supporting the warrant. Court will set bail in this case on this first-degree felony at $100,000. And Mr. Ashmore, if you want to file a motion to reduce that, then you can file your motion and give the state notice, and the court will set that for a hearing.
Yes, Judge, thank you.
All right. And so for purposes of arraignment, Mr. Hobson has entered his plea of not guilty before the court. The court will enter that into the record, and the court will set Mr. Hobson for pretrial hearing on July 8th at 1:30 if he is in jail, and 9 a.m. if he's on bail.
Judge, can I make a request that we do that on the 13th? Is that possible?
Yes. All right. So we'll set pretrial on July 13th.
Thank
Now,
you, Judge.
Now, Mr. Ashmore, on the waivers of arraignment on your other clients, do you want those set on the 8th
Yes,
or on the 13th?
I thought I had written the 13th on them, and if I didn't, I apologize.
Well, I don't know. I haven't seen them, but I thought you set them all on the 8th. I just want what I need to write on my docket, 8th or 13th.
13th, I believe, is right, because that appeared to be the least cluttered of the courts available.
All right. So for the record, CR 21-109, Daryl Chumley. CR 21-131, Jack McAllister. And CR 24-15, Clifton Thomas, have all been set for pretrial on July 13th, and Mr. Ashmore is filing waivers of arraignment in those cases.
That's correct, with the exception of McAllister. I thought McAllister was set for a pretrial today. I may have to correct that bit.
Yeah, I'll show him set for arraignment. Go ahead, Mr. Hobson. You're free to go.
Thank you, Mario.
Let's look at McAllister here.
Yes, Judge. Okay.
He's set for arraignment.
I was mistaken, Judge.
So are you filing a waiver of arraignment on McAllister, or do we need to bring him up real quick?
I can do.
Which
I
one?
can do either, Your Honor. I have a waiver, and we have met today, and he is here in the courtroom. So whatever.
If he's in the courtroom, go ahead and bring him up, and we'll just simplify it. All right, this is CR 21-131, State versus Jack Marvin McAllister, set for arraignment. Go ahead, Mr. Ashmore.
Judge, thank you. I'm going to pull that indictment up. Mr. McAllister and I have spoken at length about this matter. This is a failure to register offense, and give me just a second, Your Honor.
Do you need me to display that for you, Mr.
Yeah, if you wouldn't mind, I'm having a hard time pulling it up. I thought we were on a pretrial hearing, Judge. I apologize.
Here you go.
Mr. McAllister, is your name spelled correctly right there? Yes. Jack Marvin McAllister is your full name? And you understand that the allegation against you at this time is that you failed to register as an offender required under the Texas Code of Criminal Procedure? And that you failed to keep the state apprised of your address? And at this time, you're authorizing me to enter a plea of not guilty? Plea of not guilty today? Yes, sir? Okay. And that you want me to continue to work with the district attorney's office on a resolution of this matter at this time, correct? Okay.
And Mr.
Also,
McAllister,
third-degree felony. Sorry, Judge.
go ahead.
The punishment range, Jack, we've talked about that. And that punishment range on a third-degree felony is not less than 2, no more than 10 years, and a $10,000 fine. You understand that as well? Okay. Sorry, Judge, did not mean to interrupt you.
No problem. All right, the court's going to find that Mr. McAllister has waived the formal requirements of arraignment, that his name is spelled correctly in the indictment, and that he enters a plea of not guilty. Court will let the record reflect that plea of not guilty, and will set pretrial for July 13th at 1:30 if he's in jail, at 9 a.m. if he is on bail.
Thank you, Judge. Judge, may Mr. McAllister be excused?
Yes, he may. And Ms. Sotelo, if you'll start making your way up. This is CR 16437, State versus Basil and Sotelo. Hearing on motion to vote.
Judge, the court appointed me recently on Ms. Sotelo's motion to revoke. We do have a plea offer as of this afternoon, which is an offer of 12 months in a state jail facility. I'm asking the court for a short reset, even if it's just to be on a contested docket, so I can have some additional time to visit with Ms. Sotelo and the state about other options, if any. She has completed her community service hours, and she has caught up the balance of her financials. I don't think the state is aware of that, so we're just asking for some additional time to visit about that.
Okay, court will.
That needs to be on the contested.
Court sets Ms. Sotelo for the contested docket on June 29th, and that'll be at 9 a.m.
Thank you, Judge.
You're welcome.
May we be excused, Judge?
Yes, I think that wraps up the docket for this afternoon, at least with regards to Mr. Ashford. So yeah, you're free to go. State, I think I've taken an announcement on each case that's on my docket, unless you're aware of something else.
Everything looks clear on mine.
Okay, all right, then we'll adjourn for today. See all y'all soon.
And Judge, I believe everything was signed today, but if not, if Ms. Taberham will just call us, we can stop by on our way out this evening.
Okay, will do. Thank you.
Judge, I'll be back with that one.